Your Honor, I object to that answer. First of all, it wouldn't be an innocent mistake if they were trying
Cindy,
to
you
steal
don't
his
have to-
property.
Don't try and beat somebody you're not going to beat. This is a fight you can't win. This is a fight he can win. Stop it. And I'm trying to make a point very clear here. I know you want to continue the fight. Don't. He did it once. He already just kicked my butt in 3 words. Let him do it again.
Okay.
You're trying to plead stupidity, and you don't.
No, we're not. No.
All right, Mr. McCaffrey, do you have an opinion of what the defendant just said?
I didn't really understand what he said.
I didn't either. I was hoping you did.
No, I think
You're
I
not
understand what he's
giving
saying.
me anything that I need something that I can move on. I have nothing.
Well, and at this point, we've captured the bank, so they have nothing to make you move on it. I'm trying to throw shit out. There's a lot of that in court. There's a lot of, they have no reasons to do what they're doing, and they're going to do something because it's better than doing nothing.
Right.
You've heard the saying, sometimes better to do nothing than just to lose. Well, okay. I've already lost.
Mm-hmm.
Okay, I'm backed in the corner. I got to fight my way out of it. It may not be a clean fight.
Well, she can put the nail in the coffin right here.
No, he can put
He
the
can
nail
do
in the
it, yeah,
coffin.
but
That's my point.
Yeah.
She's not going to put the nail in the
Well,
coffin.
somebody's got to move the judge.
You're not going to put the nail. Yes, Anita, I got it. You're not going to put the nail in the coffin. Okay? He is. That's his job. Okay? He's good at it. He's getting paid for it. Don't waste your own ammo. That's silly. That's my point. Throw it all back on him. But I've already lost. And things get real funky when the bank starts losing. They're going to throw out shit. It ain't going to make any sense. So don't try and make sense out of it. You've probably heard it all before at this point, right?
I have. The next approach would be to bring up a HUD-1, bring up the documents, and most cases, I will tell you this, most cases that homeowners will get on the stand, they lose their own case. And they lose it within 10 minutes. Because 1, you're not coached. 2, if you are represented or representing yourself, you should have somebody just coach you a little bit. That's why these mock trials are somewhat, I believe, are very good. And they're good to see how things happen. But in the real courtroom, you're going to get a bank attorney that is going to want to say, in this particular case, Your Honor, they are looking for a free house. And that seems to be a clear, definitive basis for a lot of these. And the action back that we found that comes back is, like I mentioned yesterday, the answer back on cross is that, no, I do not want a free house. They want the free house. And the reason that they want the free house is because it's been paid for. And on top of it, they've provided documentations to the courts because these documents would be recorded in the courts. And I will tell you, if you want to, excuse my French, piss off a judge, supply fraudulent documents or fraudulent recording of documents like we have here to a judge. He gets upset. And the opposing counsel can be sanctioned. They're supposed to recognize these documents, and they're supposed to be able to recognize what they're going to go after. But in a case like this where John's basically lost this case based on these filings, based on this note, but they're going to come back to you and throw everything else that they can, and one of them is, and always will be, Your Honor, this customer or this person or persons want a free house. And judges aren't interested in giving you a free house. And what you have to incur and infer to them is what I really want and what I tried to get was an affordable payment. I don't want a free house. None of us ever intended on taking out a loan, if you use that term, and not paying on it. I don't think any one of you in here has ever had that intention. Because if you did, you wouldn't have made the first payment. But you have made some payments, and they're going to bring that up. And then all of a sudden you stop making payments. And the reason that you stop making payments is because you either had a death in the family or something catastrophic happened to you or you lost your job. But please try to infer to the judge and to the courts that you are not interested in a free house. You are interested in an affordable payment. And if there's been fraud upon your loan, then the judge will issue an injunction to stop this foreclosure, and if there are any other proceedings or documents that the opposing counsel can provide, they will. But in this case, there's not much more to provide here. This is pretty cut and dry.
And you didn't even get into the part of the loan that she never received. You didn't have to go there because of the other fraud,
That's
right?
going to be something that's going to be done, that's primarily done through the pleadings. This is a decision on the fraud and standing, okay? This is how you're going to win in court. The fraud on the loan is going to be what gets you this far. Don't get the two mixed up. Court is incumbent. It's brought about by the pleadings. Most of you will never get here. Our goal is to get to the point between Bill's paperwork and Horner's documents that you never get here, and there's some settlement made beforehand. This is a battle. Now, you better be ready for it, but it's far better to settle before that. Now we're going to do something a little funky. All right, go ahead, Anita.
Does this work? Yeah. Question is for Bill. You've been stating that you don't know in which order the documents were recorded, and my question to you is that usually they have a recording number, and it's the first thing I look at to see if they've screwed up and recorded them, in the wrong succession. So if the attorney for the defense comes back to you and say, "What do you mean you don't know in which order they were recorded? It says right here that it was 1, 2, 3." How do you respond to that?
I go by the date and the time. And the date and the time on these are all the same, date and time. So the order of the documents would be referred to on my behalf as date and time. And it would be up to the bank and the county recorder's office to determine when these were recorded and at what time and date. So you probably would lose that argument, especially when they are recorded within the same second. It's just not possible.
Because I have 3 documents on my case, which is basically like everybody else. I have 3 documents which are basically like everybody else, the assignment of the beneficial interest under the deed of trust. Next document, by the recorder's office. Number is the substitution of trustee. Next document, in sequence. 2,
It's
3,
all, it's
4.
all the 3.
Yeah.
The issue that you have here is not only do you have the substitution of trustees, you have MERS. Everyone has the same issues. And then you have to go back and look at the assignments, and then you have to go back to your note and look and follow those assignments and make sure that those documents follow the recorded documents as well.
Yeah, no, I understand that. But once upon a time, I used to buy deeds of trust, and the first thing I would, this is in the 90s, the first thing I would look at was, and I did see many, many times where they actually recorded the assignment in the wrong sequence. It would be a double escrow, and they'd screw them up.
Right.
Yeah. So that, but in.
And that's why they provide seconds on there.
Okay.
Yeah.
Thanks.
Okay.
Bill, I have a question. On the papers that we received, it just states recorded. It doesn't have a date, doesn't have a time. How would you go about finding that information?
What state are you in?
This is state, Arizona.
Arizona? You just go to maricopacounty.gov and pull up the recorded document that is posted on the website. And it will give you the date, time, and stamp in which, but the actual recorded document doesn't give you the seconds.
Okay, thank you.
maricopacounty.gov.
Diane, just so you know, Charles Horner found your documents. When I was looking for that, for some reason they weren't showing up, but he found them. He has some type of link that I didn't have. So I'm not sure why they didn't show up when I looked, so, but we found them.
Yes, John, this is a question for you real quick. I noticed that you was telling the young lady that it's two separate situation. Like in a case of foreclosure and eviction, what I've had to do is consolidate the two so we can combine it. Have you ever request or a motion to consolidate?
I'm missing the point. First of all, what state are you dealing with?
Georgia.
What?
Georgia?
Is it non-judicial or judicial?
Non-judicial.
And you're combining?
Yes, I've had,
Oh, that's the microphone problem. I don't think it's mine.
Test.
I've had to combine the two, or in the state of Georgia, in order for you to actually start
Okay,
fighting
hold on. Combine the two what?
the two argument, because
No.
I was gonna explain to you.
Can't combine arguments.
let me explain to you. What happened is, after the foreclosure, they proceeded with the eviction. Even though I put the complaint before the foreclosure. So they proceeded with the eviction, and what happened is, I didn't want to get evicted, so we argued the eviction, but at one point, we wanted to set aside the foreclosure. So we started by trying to put the two together. So we motioned to consolidate it, and we had put the two together. We're
Okay.
fighting the foreclosure, and now we're also fighting the eviction.
Okay, just because you motion the court, Andy, is there something we can do, man? This is driving me friggin' nuts. Ah, okay. Can you guys hear me?
Yeah.
Okay. Yeah, nope, it's this one. Okay. Okay, you're giving me like just certain pieces of the puzzle here. Are you saying that you did a motion to combine them and the judge accepted it? He did accept it? Okay.
Yes, and in the stage that we were in, he did accept it. He had no choice but to accept it.
Okay, so you're fighting the foreclosure and the forcible detainer at one time?
We've combined the two together, yep.
Okay, I don't see how you could do that in Arizona law.
Okay.
Yeah, I can't see any,
Yeah, I understand every state is different, so you're
Yeah.
right. So there's probably clause in the state of Georgia where we were able to do that. In other states, you may not. Just like in some states, you can request to set aside the foreclosure. That's the beginning of the argument. In some states, you can't do that. So,
yeah,
you may be right.
I think the biggest thing with the forcible detainer is to go after whoever did the verified statement and subpoena them. Now, if you can join the arguments, that would actually be effective in both concepts, because whoever did the verified statement after the foreclosure for the writ of restitution is probably, or I'm sorry, for the writ of restitution is probably somehow involved in the earlier foreclosure proceeding.
Yes.
So you could get them, you could subpoena them to take the stand and do everything under penalty of perjury, and they won't do it. So that could probably undo, if they're conjoined, that could undo the whole foreclosure proceeding.
They didn't reply at all, and we were just counting the days, because in federal court, you have 90 days for the court to reply, or actually 2 weeks for the defendant or plaintiff to reply, and then 90 days for the court to make a decision, whatever. We're just
Yeah,
counting-
but then
we're
you've got
counting the
Rule
time.
41M and all
Yeah,
that, and
just
it's,
counting time to see when we can make the next move, since nobody replied yet.
if I was in your situation, first thing I'd do is start issuing subpoenas to everybody and their brother, because
Okay.
you got to give it under penalty of perjury, and that may stall that thing out forever.
Okay.
There's not a lawyer, there's not a banker that's going to sit in that chair. Okay? They just won't. Everything they've done is a lie. Okay?
All right, thank you.
All right. We're gonna have some fun.